So I'm going to share with you, my viewers here at YouTube and on my websites, something that's going on presently in the courts of Canada, within the justice system of Canada, more specifically the province of Ontario. Right now, there is a constitutional challenge that is being brought forth before the courts. Now, the constitutional challenge is based upon the fact that we should not be held, or we should not be obligated to state that we are pledging allegiance to Her Majesty the Queen, and that there is an application of law or an operation of law that is available to us, that we can remove the monarchy, the Queen, as the head of state here in Canada. Now, the application or the process that Mr. Roach, this man, is using is good. The form of law is good. The reasons, his motives, because he would want to have a Republican government, and he has other reasons why, I don't totally agree with. But nevertheless, the constitutional challenge and the applications of law, I agree with. And it's great to see that he's doing this. When he first laid his claim, he made a few errors. He didn't name the Attorney General in his constitutional challenge. If you've been watching my videos, you've seen that if you're going to launch a constitutional challenge, specifically for your own fundamental rights and freedoms, you must name the Attorney General of your province and of Canada, and you must serve them. Well, this man, he failed to take that action of law. The judge, however, provided him an excuse and said, although you didn't serve them properly, I'm going to give you an excuse and you can serve them properly going forward from now. What the Attorney General was trying to do, he was trying to have the case dismissed, a motion to dismiss this action before the court. However, as you're going to see, the judge in the Superior Court denied the Attorney General's motion to dismiss the case, and he has decided that he is willing to hear the case. And the case is being built upon the fact that we, all of us, should not have to pledge allegiance to Her Majesty the Queen, and that we should have her removed as the head of state of Canada. Ontario Superior Court of Justice, between Charles C. Roach and Her Majesty Queen Elizabeth II, represented by the Minister of State, Multiculturalism and Citizenship. Now, he made a mistake here. The judge ordered him subsequently to change this and to serve the Attorney General of Canada, and he has subsequently done that. So he has a case now in the Ontario Superior Court against Her Majesty the Queen Elizabeth II. This case was heard on May 8th, 2007. And I want you to notice the title or the designation that is being used here. It says applicant and respondent. Charles Roach has commenced an application under Rule 14.5 and the Class Proceedings Act 1992 to challenge the constitutionality of that portion of the Canadian Citizenship Oath as set out in Section 24 of the Citizenship Act. That requires new citizens to swear allegiance to Her Majesty the Queen. So this man has laid an application before the Ontario Superior Court saying that he does not believe or he does not think that we should be forced to swear allegiance to Her Majesty the Queen. And he's saying that this action is against the Charter of Rights and Freedoms of Canada. Now, here is the analysis from the court itself. Question: is there a reasonable cause of action? I begin, now this is a judge, the court speaking. I begin by noting that the applicant is not challenging the fact that Her Majesty, the Queen, is Canada's head of state. The fact that the Queen is Canada's head of state is constitutionally prescribed. So you're hearing this by Section 9 and 17 of the Constitution Act 1867. Canada is a constitutional monarchy. So by this declaration here, we see that the courts, the justice system, are aware that Canada, or Her Majesty, the Queen, is indeed head of state of this constitutional monarchy. Now he continues to say, the applicant and the proposed class of litigants are challenging the content of the citizenship oath, and in particular, that portion that requires them to swear allegiance to the Queen. There is nothing in the Constitution Act that requires a Canadian oath of citizenship or that a new citizen must swear allegiance to the Queen. The point of these introductory comments is not to question the merits of the federal provision that is being challenged herein, but only to indicate that the content of the Canadian citizenship oath is not constitutionally prescribed. It is simply the consequence of an ordinary federal law that can be amended or repealed by the federal government, or, as here, can be the subject of a constitutional challenge. Mr. Roach and the other members in this proposed class action would like to become Canadian citizens, but they would also like to see a constitutional amendment that would remove what they believe is an undemocratic vestige of a colonial experience that has no place in a modern and independent Canada. It is important to note that Section 41 of the Constitution Act 1982 provides that the office or role of the Queen as a country's head of state can be changed or even abolished by a constitutional amendment. So you're hearing that. The applicants say that the requirement to swear an oath or make an affirmation that they will be faithful and bear true allegiance to Her Majesty the Queen violates their freedoms of conscience, speech, and in more particular, association. They believe in a republican form of government, and they want to advocate a constitutional reform that would eliminate the British Queen as the Canadian head of state. They cannot do this, they say, if they are required to swear an oath that they will be faithful and bear true allegiance to Her Majesty the Queen. The article argues that the current Canadian citizenship oath, which contains an oath of allegiance to the Queen, is constitutionally infirm. Specifically, the article argues that the citizenship oath violates subsection 2A, subsection 2B, and section 15 of the Charter. It violates freedoms of conscience and religion, if not in purpose, then in effect, because those who would be the object to taking the oath for the consentness reasons are forced to choose between citizenship or being true to their conscience. The oath requirement violates freedoms of expression by limiting the range of available options. It constitutes discrimination under Section 15 because it is based in part on prejudice against outsiders and implies disloyalty. The constitutional challenge to the requirement that new Canadian citizens swear or affirm an oath of allegiance to Her Majesty the Queen, and not simply to the country, its people, and its laws, is neither frivolous nor vexatious. There is a plausible argument that this requirement violates the Charter of Rights and Freedoms. There is evidence filed by the applicant that suggests that the requirement in a Canadian citizenship oath to swear allegiance to the Queen may not be a reasonable limit that is demonstrably justifiable in a free and democratic society. There is at least a possibility or a chance of success. There is no abuse of process. The Federal Court of Canada is not a more convenient form. In my view, this matter can be litigated in the Superior Court of this province. The motion to strike out or stay the application is dismissed with costs. If the parties are unable to agree on costs, I will be pleased to receive brief written submissions from the applicant, Charles Roach, within 15 days of the release of these reasons, and from the respondent, Attorney General of Canada, within 7 days thereafter, so that now the judge could decide how much cost he would award to Charles. In reasons released on May 17, 2007, I dismissed the respondent's motion to strike this application, which involves a class action constitutional challenge of that portion of the Canadian citizenship oath that requires new citizens to swear allegiance to Her Majesty the Queen. Again, this is the justice system, the judge speaking. I concluded that there is plausible argument that this requirement may be in violation of Section 2 and 15 of the Charter of Rights and Freedoms. I also found that there was no abuse of process in relitigating this matter by way of class proceeding, and that the Federal Court of Canada was not a more convenient form. I concluded that the application was properly brought in this court. The proposed claim alleges that the oath forces the plaintiffs to express allegiance and faithfulness to a royal family and/or monarchical form of government, and to disavow Republican thoughts and activity or their religious, cultural, or moral beliefs. As a result, the plaintiffs allege that the defendants has infringed their rights under Section 2 and 15.1 of the Canadian Charter of Rights and Freedoms. The plaintiff seeks the following relief: a declaration pursuant to Section 52.1 of the Constitution Act of 1982 that the statutory requirement to take the oath with the impugned words violates the Charter and is invalid and is of no force or effect. The plaintiffs may issue a fresh statement of claim or application and must do so no later than September 21st, 2012. This includes service of the claim or application on the defendant. By the end of September, the parties will agree on a timetable for moving the proceedings ahead. The Attorney General, as I stated, he lost his ability, or he lost his motion to dismiss the case. Now the case is being held before the Superior Court, and it was resubmitted, or everything was brought up to date, if you will, in September of 2012. And they're setting a time limit presently on how this case is going to be heard and what's going to transpire in this case. So for all those who are interested, I'm going to have a link attached to this video where you can go to Canly and you can read about what's transpiring and you can follow it on your own. What's important to note here is that as you read and study the case, you can see the operations of laws that he is using, the operation that he has used to get himself into the court, before the court, to launch a constitutional challenge. These are similar, not totally the same, but similar to the operations of law that we will use as human beings when we launch constitutional challenges.